Now that
itself.
you have started.
Assembly Bill 405 deals with parental notification, and I have some other folks coming up that are going to give you more of the specifics, but what I want to make clear is this is actually modeled on a Minnesota law that went into place in 1981. It functioned in Minnesota from 81 to 86. It was then challenged judicially, went all the way to the United States Supreme Court, and in 1990 it was found to be constitutionally proper. And so you have a 25-year track record of this almost identical bill in the state of Minnesota. And in fact, there are 38 states that require at the minimum parental notification, 21 states that have even a higher bar, which is parental consent. I think it's very important that everybody in the committee and in the Senate understand too, this is not parental consent. This is simply parental notification. All 38 states also have a judicial bypass mechanism, which is required by the 1990 Supreme Court decision. This bill also has that same judicial mechanism. Politically speaking, in 2011, Mr. Gallup conducted a poll on this very issue. The question that he asked was, would you support a law requiring women under 18 to get parental consent for any abortion? That's consent again, a higher bar. 71% said yes, 27% said no. It had strong bipartisan majority support from both parties. In our current legislature, we've had several bills. AB 206, which is commonly called the cyberbullying bill that requires parental notification. We also had Senate Bill 504, which requires parental notifications for all students involved in bullying. That requirement is within 1 day. In 2013, we passed Assembly Bill 144, which required parental notification for minors if they want to decide to be an organ donor. In 2013, we also passed the Senate Bill 267, which did not allow anyone under 18, even with parental consent, to use a tanning booth. We also have in the NRS right now laws which say that even if you're 18, you cannot buy cigarettes. We're passing a law currently on vaping products. They cannot use medical marijuana, firearms, spray paint, stun guns, certain ammo. Tattoos. When my daughters went to get their ears pierced, they actually had to have their mother with them with their photo ID and their birth certificates. And even to get something as simple as aspirin at school requires parental notification. The judicial bypass mechanism is sometimes brought up as perhaps a hindrance to this. As you will hear from the opponents, they're going to give you some horrendous stories about what potentially, hypothetically could come up. And they say, well, what happens, for example, if you have a 15-year-old who's pregnant? She's obviously not going to know to go see an attorney or a judge or something. How is that handled? And the way it actually is handled in all the many states that do this is when they go to a clinic, the clinic will assist them in going through that process. So I want to make sure that's understood. This is in no way an attempt to try to stop abortion. This is simply a notification. As chair of the Judiciary Committee in the Assembly, we heard bill after bill, which we dealt with in many times, the issue of minor accountability. Underage kids, 18 and under, what level should we hold them to accountability for their actions? And the reason it became an issue is because we had numerous frequent testimony dealing with the issue of brain development. Turns out that under the age of 18, the portion of the human brain that deals with consequences is not fully developed, and we had testimony suggesting that that doesn't occur till at least the age of 25. So again, if at the very least, if we're going to be consistent and we're going to insist that minors have parental notification and parental involvement in all the other things, it would seem to me that such concerns over brain development, especially in the consequences area of the brain, would be strong support and reasonable standards for insisting that parental involvement in such a serious medical decision as an abortion is also taken into account. Of the 38 states that require at the minimum parental notification, none of them have revoked that law, and maybe only minor adjustments. For the most part, all of the horrendous stories you're going to hear about what will happen in this situation and that situation simply hasn't come to pass. All those states have kept those laws on the books for as many as 25 years. This is a tried and true law. This is not experimental. We can show in other states the exact results and consequences. The number one positive thing that came out of these other laws in these other states has been a substantial reduction in the number of abortions. And has there been a consequent rise in the amount of domestic violence situations and things like that? There's absolutely no evidence to support that. And as I said earlier, all 38 states that have these laws have kept them on the book in some cases for decades. So, Mr. Chair, with that, we have a whole bunch of folks that would like to testify on this bill, as you know. I do request, if I could, at the conclusion of the hearing, an opportunity to come up and perhaps say some final words in response, but that will be your call. I think all of us, I'm the father of 8. I've got 4 daughters. I've got 5 granddaughters. I have 4 sisters. I love women. I love my children. I love their future. I want only the best for them. And like all of us, I live in the real world. I've dealt with some of these issues in a very personal way in my lifetime. And I think that at the very least, we should want to encourage the involvement of parents with their children in significant medical decisions. You can put aside the issue of the morality of it, but simply ask yourself, in any medical decision, if we're going to require parental responsibility and involvement on giving a child an aspirin or having their ears pierced, surely a medical procedure as involved psychologically and physically as an abortion, shouldn't we want at the very least that same level of parental involvement, if at all possible? And that's what this bill is attempting to do. And with that, Mr. Chairman, I will go aside. I believe you have a list of folks that want to testify.